All right, Senator Hertzberg, this is file item 16, SB 1329. Good afternoon, sir.
Thank you kindly, Madam Chair. It's been a long day. About interesting bills. This bill allows appeals of aircraft assessments to be treated like other state-assessed railroads and utilities. That's what the bill does in large measure. And, you know, this is not my issue, and something happened on the road to somewhere that got me involved. I guess it's being chairman of that committee that Lois Walk finked me out on. And so, you know, it's one of these things where I saw this problem, and it's, you know, I saw it when I was here before on this larger issue, and you know, I know the rhetoric around this, and this is one of these issues where it's easy to discredit rich versus poor, single entity bill, you know, and it's easy to deal in the rhetoric. But what I want to do is to take you to the basics. And the basics are that when a county has property within its county, there is a constitutionally long-established process that assesses those properties, buildings, properties within the county. The government, some more than 100 years ago, our government, people that sat in these rooms before we did and warmed up these chairs before we did, basically said that if it's a statewide interest, a railroad, a utility, a telephone, things that existed back at that time, that we would then have a different process. That process would include an appeal by a judge as opposed to the control of the county. Airlines didn't exist. This is not some great grand theory of conspiracy. This is, airlines didn't exist at that time. They came into business 4 years later. And so the question becomes, and what we've been grappling with, which always happens in the issue of power, is folks have their play. They play their issues. And, you know, if you look at what's happened here, what are we asking for? What grabbed my attention as somebody who studied the Constitution my whole life, and father was a constitutional lawyer, is the idea that any entity can have itself as the prosecutor, the judge, and the jury. And that's what grabbed my attention, these assessment boards. We have been engaged for years now through litigation, through other legislation, in a process of how do we deal with these assessments? The nature of aircrafts, how does it work? And we've gone back and forth all over the place. And so what I'm trying to do, and the reason why I engage in this thing, is to really get to the issue of coming up with a process that works. Because the truth of the matter is, when you have an entity, whoever that entity is, that has interests that are in conflict, there is no check and balance. Now, the argument here, of course, by the other side that we've all heard, because there's, you know, a couple of folks that are running around pushing pretty hard against this thing, is that you have this David and Goliath situation, that you have these airlines that are really rich and powerful and these governments that have no power, and they're going to use their armies of lawyers to create this imbalance. But the truth of the matter is, common sense still reigns. These are not issues of civil rights or core justice issues. These are issues of money. People make decisions based upon money. And so no airline company, of which there's only a handful of them that deal with this issue in the state, are going to go and spend a bunch of dough unless they feel that they've really been unjustly treated. And so if you have this, you know, what we've already seen in one county by virtue of an independent audit, a process, at least in the one instance, the only instance where it was examined, where there was quite significant questions by an impartial Santa Clara County assessment appeals process. I know, what is that? It's pretty good. They're supporting the bill, baby. They're supporting the bill. We got the Lord on our side. I take that back. So
What is this with people singing around here?
Yeah. How can we have the Lord on our side on this when we're just talking about money?
it's about money.
There you go, okay.
Well, you know, there's some preachers that talk about money, and you give the money, and it helps you feel better with the Lord. I got a prayer cloth here that I can sell you. Yeah, all denominations. So that notion, but the reality is, if the process is fair, and if the numbers aren't so insignificant in terms of where it's about, and you reach a balance, you're not going to have that problem. You have the problem as a practical matter. Now, let me just tell you, the fact of the matter is, all these arguments about the impacts, airlines pay up front, right? This is not as if you're not paying. You're paying up front, and you've got to appeal to get your money back. So it's an economic decision. It's not as if the county's without the money in terms of what's going on. So that whole David and Goliath situation, I think, doesn't fairly analyze what the factors are that otherwise exist. And the second issue that I've heard a lot about from members of this committee, from the folks that are lobbying against this, is that somehow there's a big tax break. And that tax break was as a result of the airlines screaming and pleading because of what happened as a result of 9/11. Well, first of all, this situation happened in 2005, but the reality is it's a valuation process. And the valuation process, I don't want to go into great detail, but in essence, just like with your automobile, there's a Kelley Blue Book. And there's a difference between buying one car or 100 cars. We just saw 80-some airlines go on the market, and these Kelley Blue Books basically determine the price. And what we look, and I looked at all the other states, and here's Alabama, Georgia, Louisiana, Missouri, North Carolina, 20% discount, 20%, 20%, 30%. These are not out of the ballpark, and the issue is not about some kind of tax break. The issue is, how do you calculate these economic circumstances? I don't give I mean, I care about the airlines industry because I use them every week, and they ultimately impact the country, but beyond that, it's not my issue. You know, whatever they've agreed to, when you look at the facts here, what happened? The assessor from the city of Los Angeles, county of Los Angeles, Mr. Prang, in his letter, doesn't go crazy on that issue. He basically says that something to the effect, I had it here, is that it caused them a little bit of indigestion, but it's not something that really makes them upset. The assessor, who we spoke to from the county of Orange County, Mr. Parrish, says he supports the bill. Assessor from San Bernardino County, Mr. Dutton, used to serve in this House, says, I see no problem with this. This is not something that, you know, certainly San Francisco, I've heard, has some issues with it. We certainly know that there's another county that has issues, that has had issues in the last 20 years. I've been involved in this legislature that comes up and argues these points. But the bottom line is, you know, what I'm trying to get here, at the core issue here, is a trial de novo. And that trial de novo, ladies and gentlemen, is a two-way street. So if, for example, you're in a situation where the assessor doesn't like it, they can appeal. Both sides have the right to appeal. There's no inequity in that regard in terms of what goes on. So look, as I see this, and what motivated me, this is not some bill that was on the top of my list to do this, was this underlying issue of how government operates. This is not, by its nature, a one-off bill for an industry. It's a correction of a historical error that has continued to be a challenge among people that want power for their own purposes. The question is, we as a government have to come up with a fair process. And I think that this larger notion of having a trial de novo where the courts have jurisdiction that can make these determinations is ultimately how all of us in the criminal system and the civil system resolve our disputes. That's what the Constitution determines. Now, there were two amendments here that I wanted to quickly address, both of which wasn't an issue. Number one is there's some discussion that apparently was some big issue about a trial calendar preference, which was simply a mistake in a cross-reference to a code section. In every indication, Madam Chair and members, we never, ever, I would have known about it. I'm upset with myself that I didn't catch the cross-reference because I pay attention to details. It was a screw-up. It wasn't an intended issue about trying to give anybody an advantage. And the second issue that was raised in the analysis that I think is quite reasonable, that we're happy to take, is the trial de novo. The analysis suggests the trial de novo be made prospective because there's pending cases, right? And only applies to future cases. Totally reasonable. Happy to take the amendment. Those are the two suggestions, both appropriate. appropriate, both reasonable in the analysis that we'll take. So I know that there's been a lot of noise on this thing, but, you know, I just can tell you from experience that it's coming from, really from one county, you know. And I mean, if you really look at it, because we've talked to the other assessors, nobody's having indigestion. If you look at, even at Mr. Prang's, who's a wonderful guy, his deal, he's afraid a little bit about the trial de novo and the issue of the David and Goliath situation. But at the end of the day, in government, the underlying constitutional framework, if you balance interest, if you balance power in a way that's intelligent, you avoid either side from taking advantage. And that's ultimately what we're wanting to do with respect to this measure. I'd ask for your support.
Thank you. So we're clear, Senator, you'll take the amendment removing the priority, and the other amendment that, so this will be prospective for future assessments only, not for
That's
things
right.
that are.
Not for the pending cases. It makes perfect sense. You don't want to, in any respect, you don't want to disrupt the current calendar. That's not appropriate.
Well, that's helpful. I don't know if it takes off opposition, but it certainly was a concern with this committee. So with that, 2 witnesses, 2 minutes each, if you'd like to go ahead.
Thank you, Madam Chair and members. Tim Taylor, working with Lang Hansen O'Malley Miller, representing Airlines for America. During the interim, at the behest of Assemblyman Nazarian, we got together in discussions with the county assessors to try to work within the Lead County system in an attempt to improve it. We really believe, quite frankly, that there should be a centralized assessment process, quite frankly, at the BOE, much like there is in every single state in the union that has multiple commercial airports. However, we're willing to work, and we believe that's a massive concession on our part to even be trying to work within the Lead County system to find improvements rather than seek centralized assessment model. To that end, trial de novo for us is a virtual panacea, really, to be honest, in terms of the improvement that it gives the Lead County system. It gives the airlines real independent review in the courts. And by opening the possibility of real court review of assessments of commercial aircraft, it will have the effect of requiring assessors to more carefully consider all evidence of value prior to making the assessment, and require Assessment Appeals Board to more carefully consider appraisals and expert testimony bearing on value in appeals hearings. The result will be more thorough, well thought out, and better assessment practices, ultimately resulting in less litigation. In short, I believe that it really gives us and Superior Court the ability to check the homework of the assessors, in essence. And that is a very insular process right now. You have at the AAB is comprised of members that are recommended by the Board of Supervisors, and oftentimes the Board of Supervisors receives recommendations from assessors. It is a very insular system right now, and we believe that by checking their homework, it will give us the relief that we need, and we're happy to keep this system in the Lead County system, the assessment process in the Lead County system. That's really about it. We respectfully ask for your aye vote. Also with me is Eric Methke, who's capable of answering any technical questions that might come up. Thank you.
Thank you very much. Next witness in support, 2 minutes, please.
Thank you, Madam Chair. Kate Bell with Capital Advocacy on behalf of American Airlines, and we're here in strong support of the bill. This bill just merely provides a very fair appeals process for the airlines and puts us on par with other public utilities and railroads. Currently, the issue, as noted in your analysis, is that a court must uphold an assessment appeals board decision if there is merely evidence that's credible in the record, and that's a problem for us. A trial de novo would allow the court to consider expert testimony, appraisals, and other information in determining the validity of the assessment done at the local level. I just want to be very clear that we are not seeking a tax break here. In fact, the bill keeps the current statutory methodology in place. It extends it for another 5 years. It keeps the assessment at the local level, which was a give on the airline's behalf. And we really think that it will give us a fair appeal process. Respectfully ask for your aye vote.
Thank you very much. Other witnesses in support, very briefly? Name, rank, serial number, please.
Kathy Van Osten, MVM Strategy Group on behalf of United Airlines in support.
Thank you.
Catherine Reeves, Public Policy Advocates for Southwest Airlines, support.
Thank you.
Hi, Madam Chair, members. Joe Ackler on behalf of Alaska Airlines. We support the bill.
Thank you very much.
Jennifer Barrera on behalf of the California Chamber of Commerce, also in support.
Thank you.
Therese Tomei, California Taxpayers Association, also in support. Thank you.
Thank you very much. Any other witnesses in support? Witnesses in opposition? All right, Good afternoon, gentlemen. Who wishes to go first?
Good afternoon, Madam Chair, members of the board. Thank you for your patience this afternoon. It's been a long afternoon. My name is Rich Benson. I am the president-elect of the California Assessors Association and the assessor for Marin County, where I've worked for the last 30 years. Because the president of our association could not be here today, I speak to you on behalf of the California Assessors Association to express our strong opposition to SB 1329. This legislation, as proposed, not only allows for special treatment for a particular industry, but a different justice track for the airline industry. And not only does the bill perpetuate a valuation methodology that was put in place to provide short-term relief after 9/11, but also this legislation would allow for a complete new trial de novo, in Superior Court after a decision has been rendered by an independent, knowledgeable local assessment appeals board. In some measure, this is not a perspective to put this industry on par with state assessees. It is still a locally assessed property, which is very different from a state-assessed property, which is frequently regulated by some regular authority like the PUC. So please don't be confused. They're very different species. Currently, local assessment appeals boards across the state work effectively to resolve assessment appeals. For 13-14 fiscal year, there were over 128,000 assessment appeals resolved. Assessment appeals board members are knowledgeable professionals with special expertise in that area of knowledge. Over 25 years ago, in recognition of the specialized understanding necessary to render value opinions on complex appraisal matters, the legislature enacted eligibility requirements for board members and followed up with mandatory training requirements for the Board of Equalization. Specialized assessment appeals boards are more likely to be able to analyze and correctly resolve complex valuation issues compared with the courts. An appeals board duty is equalization as compared to the legal environment, which is more conducive to settlement and negotiation. And I'll repeat that, which is very important for local assessments, that the court process is more conducive to settlement and negotiation than an appeals board, which is trying to figure out what's the value of the property. The goals are not consistent with the constitutional requirement of property tax equalization. The idea of trial de novo is inherently not one of equalization. In its proposed form, it will benefit one specific industry. A concern going forward would be that trial de novo could expand to other large industries or corporations who can afford protracted and expensive legal battles. Trial de novo will rarely, if ever, be used by a residential property owner, if not simply beyond their means. On the other hand, what would the public perspective be that some property taxpayers have opportunities before them that are not available to all? That is one of the fundamental principles of taxation in our land.
Thank you, sir. I slipped up and I let you go a little too long. My apologies. Next witness, sir.
Thank you, Madam Chair. My name is Thomas Parker. I'm a deputy county counsel with Los Angeles County Counsel's Office. I've been a property tax attorney since 1994 for 5 counties. I was the assessor's counsel in El Dorado and Sacramento counties. I was the Board of Equalization, or AAB, counsel in Colusa, Mendocino, and currently Los Angeles counties. First off, the Los Angeles AAB has 33 filled positions, 35 on the books, 33 are filled. Of those 33, 19 are real estate brokers, 12 are licensed attorneys, including one who is a retired Superior Court commissioner, 1 CPA, and 1 real estate appraiser. In El Dorado and in Mendocino, They also employed qualified independent members of the public, including real estate brokers, attorneys, and one property investment developer. As has been alluded to before, there is a very clear structural firewall between the assessment function, which is the county assessor's function, and the appeal hearing function, which is the Independent Assessment Appeals Board, which is totally unlike the state board, which the state board not only sets its values in May of each year, but it also hears appeals in December of each year on the values it has set. It's a very different system. The Board of Supervisors appoints independent members of the public meeting the statutory qualifications. And I've been doing this for 22 years as both sides of the AAB litigation. I can assure members of this committee that AABs are independent and they are not predisposed to go towards one side or the other. They look at the cases and the evidence presented to them and they make their decisions. The Legislative Council in July of 2001, and it's referenced in your staff report, issued an opinion stating that trial de novo for local AAB decisions is unconstitutional based on a 1946 decision, Covert v. State Board. The key facts the committee should be aware of in this 1946 Cal Supreme Court case, which is still good law as we sit here today. The legislature had broadened the trial court review of liquor board decisions, which were constitutionally given to the state board.
I have to cut you off. I'm very sorry. I think this is, I think, going to be a robust discussion, but the time is allotted is done. Thank you. Other witnesses in opposition, sir.
Thank you, Madam Chair. John McKibben on behalf of the California Association of Clerks and Election Officials. We are the administrators of the County Assessment Appeals Board programs, and we are charged with the responsibilities of maintaining a level playing field for everyone. Thank you.
Thank you. And
no vote.
Okay. Thank you.
Good afternoon, Dorothy Holzman with the California State Association of Counties in respectful opposition. Thank you.
Thank you. Next witness, please.
Michael Radigan on behalf of the Board of Supervisors, Santa Clara County, in opposition.
All right. Thank you. Other witnesses in opposition?
Hi, I'm Kathleen Kelleher, the elected assessor of Sacramento County, and I urge you to oppose this bill. Thank you.
Thank you.
My name is David Ginsburg. I'm deputy assessor with Santa Clara County, and we are strongly opposed to this. And if you need us to answer any questions about what was brought up earlier about our county, please let me know.
Thank you, sir. Any other witnesses in opposition? All right, seeing none, let's bring it back to the committee. There's some things that are viscerally one way and viscerally another, and I am viscerally completely confused. So, I think I understand the argument. In support, there's concern that there is a lack of independence and that the assessors and then the appeals board are essentially not necessarily one and the same, but way too cozy, if you will. So that seems to be one of the arguments. I'm wondering if there's any data that demonstrates that belief. I mean, is it that there's never been an assessment that's been overturned, or there just doesn't feel like there's any fairness? I mean, because there's some serious allegations about what this bill really is attempting to do. And I guess today, Michael Hiltzig of the LA Times came out with an article that I've read just today at 11:22 a.m., I believe. So I assume it's online, that talks about this bill and basically accuses the bill of really being a not too, or a fairly transparent effort to gain greater leverage by the industry so that they don't have to pay as much in taxes. That's the allegation. But your argument seems to be that there's not a fairness at the grassroots level, at the assessor level, and that the de novo would give you a chance to have greater independence and objectivity. So if I understand that correctly, could you tell me what is the data that you have that shows that in fact there is this lack of independence or integrity in the process that exists today?
2 points. One, I asked that very question of the airlines, and they gave me examples of the variation of up to 70% in terms of valuation, where they, and basically, I mean, think about this. It's almost like being a pro per in a case where someone's trying a case.
Don't persuade me that the airlines are pro per.
Oh, no.
These guys have a lot of money.
It's not about money. It's about justice.
Okay.
And it's what grabbed my attention, because what happens is, since you don't have an appeal, this is a fight. If you think about it constitutionally, which grabs my attention, I have a right to a court of appeal. I have a right to the judicial branch of government. This notion that this isn't being applied to all is exactly opposite. It is not a sympathetic case because it's the airlines, but it is a constitutional principle that needs to be applied fairly. And the reality is that when you have things that are multi-jurisdictional, we have a process. If there's anybody who's being treated differently, it is the one place that happened to be invented after the fact of when the law became the law, and there has been this game that's been played ever since. And so I'm sitting here and I'm trying a case, or you're trying a case, and they come up with something that's crazy. And you have evidence that I have here. It talks about right here, this just happened in July of this year, an independent report. I don't know what's happened in LA County and other counties. I know that Orange County supports this. I know that San Bernardino County doesn't have a problem, but they say current county practice does not appear to follow California constitutional requirements, which mandates uniformity in processing decisions of assessment appeals. So the answer to your question are three things. First, there are anecdotal examples of where the numbers are wildly different in terms of where you are. B, when you have that sense of injustice, like these guys came down and are picking themselves and all these things in a report, and I have no remedy. I cannot, what is 3 branches of government for? Why do we have a judicial branch of government? Now, you could argue in the most extreme cases where there's abuse of process and the like, you can appeal, but your remedies are very limited. But so the notion is that what you're really doing here is conforming on a statewide basis, that you have this tremendous frustration where people can't appeal because they don't have that remedy. That's the difference. And I would suggest to you, with respect to the story you just referred to, he interviewed me as I was walking into a committee, and the report came online, I don't know, within a matter of minutes afterwards. It sounds like it was already written in terms of being able to make your case. It reflects a similar story that was written over a year ago, which was referenced in terms of that issue with respect to that one person's point of view. But from my point of view, that this is a sense that I at least want to be able to have a judicial review. And I just want to say one other thing that's important here. This notion that the courts have no competency. I'd love to make that argument to judge. Sorry, judge, you don't have competency. This is too complex to somebody who's handling a difficult antitrust case or a highly difficult labor case or whatever the case may be. Judges are learned in the law and gathering evidence, and that's what they do. The notion of assessments and valuations are not more complex than so many other cases that affect you. You marry that against the notion that I want my day in court, and this says, sorry, you can't do that. But everybody else that has a statewide play. And the last issue is that the assessment people made, which is quite important, but answered that somehow the assessors aren't involved. No. They absolutely have a right. They have developed through their association a lead agency approach, which we adopt, and Mr. Nazarian adopts, which they don't oppose. And they come up with a process, and then everybody else agrees in the lead agency. So this really goes for the egregious cases and creates a check and balance to make sure that the parties don't go out of balance. And what we've seen is that there have been issues. If it turns out that you know, the airlines are doing what people want to suspect that they're doing, hiring expensive lawyers, spending tens of millions of dollars, I suspect that there will be course correcting in the process going forward. I don't think at the end of the day that's what's going to happen, because nobody hires lawyers to lose money. They hire lawyers to make money, and so they want to create equity and fairness in that process.
Thank you. I'm going to defer to my colleagues. I know there are going to be some questions. I may have a few at the end, but did you want to respond to that?
May I?
Yes, go ahead, and then Senator
Thank you very
Wieckowski.
much.
Yeah.
Just for a brief second. The question arises as to why other than the trial de novo, taking it out of this fairness place from all taxpayers, but also this question about, well, how do you create this level at the Assessment Appeal Board that ensures impartiality? I would suggest that that's not hard to do. The Board of Equalization certainly has the authority and does have the authority and exercise it to set standards for the Board of Equalization. That's easy enough to do. They have training programs, they have ethics, they have standards. Why not raise that bar for appeals board members? I don't think the Assessors Association would have an objection to that, to raise it to a level to ensure that there's a material effect to the airlines and any other industry that boards are in fact impartial. That's a simple solution without taking it out of the environment of a local assessment process and raising this other standard of a legal path, a legal track that's different from everybody else.
If I could, Madam.
No, let's go on. Thank you. Senator Wieckowski, if there's an opportunity, we'll ask you a question. Go ahead, Senator Wieckowski.
I guess I need to state that I'm not persuaded that that you're going to change the local assessment so that property owners, people who own real property in the county, are going to want to have their trial de novo. The author reminds us that in 1910, when we had property that crossed county lines, that's what the constitutional amendment did. When property crossed county lines, they gave the assessments to the State Board of Equalization. And anybody could, I guess, done a constitutional amendment to add airlines, because I think intuitively airlines meet this standard. You are flying from one county to the other. So it seems to me that this bill protects that local interest by having you to continue to be the lead agency. I mean, I knew nothing about this before I read the analysis, but I don't understand it seems to me that that's a fundamental distinction between airlines which are assessed by the county and all the other real property that does not get to move from the county. I mean, can you respond to on the face of it, that the Constitution, or at least the decision in 1910 said, if this property crosses the county lines, it should go up to the Board of Equalization?
Well, if I may respond, Senator. First off, if anyone wants to amend the Constitution further to add airlines to the existing list of state assessee categories, that is certainly up to the proponents of that amendment and to the voters of the state of California. At the current time, however, rightly or wrongly, airplanes, whether they're certificated or whether they're Piper Cubs, whether they're owned by airlines or whether they're owned by John or Jane Doe in the county of X, is personal property that is assessed by the local assessor. And given that current constitutional status and legal reality, trial de novo is not warranted for airplanes.
It leads me to because this is somewhat of a hybrid that my colleague from Los Angeles has created, because he's allowing you to remain as lead agencies rather than just requesting that we transfer it to State Board of Equalization. But it gets to the idea of fairness, because, it seems to me that I have some concerns, and I'll be asking the author, but I want to ask you guys about the 10% discount. Great that Missouri's got a discount and Alabama's got a discount, but if we're really looking for the evidence of the valuation and asking the assessor to do their work, I'm not inclined to support the bill that still gives a discount. I mean, it is what it is, and they can bring in their professionals, and the assessor can as the lead agency can look at that. Tell me are you concerned about the 10% discount with the what's it called, the sunset that's being continued in this bill? Is that?
So I think fundamentally, that the 10% discount may not be the biggest issue on the table. Assessors, I think, would agree with you that really the standard is market value. That's the constitutional standard in California, that for local assessment, it's assessed at fair market value. I think the fundamental difference that you're referencing with regard to if we did something where it raised to trial de novo, why doesn't that make sense to be local as opposed to state? And I think the issue that stands there is that utilities at the state level are regulated by the state and assessed by the state. You would have an agency or a industry, airlines, that have no form of regulation, but yet have this special opportunity for trial de novo. And that flies in the face of all the other utilities that are regulated at the state level.